Hello everyone. Today we have a legal scholar and a practitioner who has decoded the complexities of commercial law and has become the authority on the subject. Sir is an expert in mediation and a certified trainer in the Mediation and Conciliation Project Act. Sir has also written his book on Commercial Courts Act 2015, a commentary and a compendium on Commercial Courts Act 2015 Part 1 and Part 2. It's my honor to introduce our guest, Shri Prashant Chandra, sir. I welcome you to the channel, sir.
Namaste.
Okay.
Thank you.
Okay, sir. Sir, in your book, you have explained us about how the transition towards the mandatory mediation is happening. It's been 5 years ever since you have written your book. So, do you think that a good faith in participation of mediation is actually happening at the ground level?
Certainly. My first book was in the year 2021, immediately after the COVID-19 pandemic. I have brought out the book in 21, maybe in end of 21. And as you rightly said, it's already completed 5 years now, or end of 4 years and plus. The purpose for which the act was brought in, particularly the purpose for which the compulsory mediation was brought in, namely pre-institution mediation, I would say has served its purpose. People are now slowly realizing that mediation is a very effective alternative, and therefore through mediation they can probably resolve most of their conflicts, disputes, particularly keeping in mind that it is a dispute which is commercial in nature. In short answer, yes, it has served its purpose.
Okay, sir. So, coming back to your book, you have explained us about how these commercial courts have actually speed up the process of recording the evidence. But these days, if you see, most of the business transactions, they are happening through WhatsApp, emails, basically online platform. So, do these courts actually have the capacity to deal with such online or a modern issues?
You are right. The act is inclusive of all that. It is not that for the first time we are getting all these complexities in the process. It already includes that. You also should know that there is an amendment which is proposed to the Commercial Courts Act 2015, and probably that will be brought into the amendment. The amendment will be brought into shortly, which means what you now ask me about the whether new technology, the digital evidence, all that will be taken care more effectively in the amendment and also in the existing act.
Okay, sir. So, basically this act was brought to make the business doing easy. So, do you think that after the act was bought, it has made our foreign investors to believe that in India the disputes are going to be resolved sooner than before, or there is still a gap?
I can't comment on that because I have no information or statistics about that.
Okay.
But I can say that there is definitely ease of doing business. Ease of doing business is the first criteria for the Commercial Courts Act, the objective of the act. That definitely has served the purpose. And it is also taking little more time. Maybe the people have to be sensitized little more. The government also should take little more initiative in making this Commercial Court Act more relevant, more commercial stakeholders should approach this. They should not think that the Commercial Court Act or the pre-institution mediation is a cumbersome process or a compulsive process. It is a very, I would say, party-friendly process, commercial court party-friendly process. And if that is seen from that angle, I think it is doing a lot more. And the concept of pre-institution is a big game changer in Commercial Courts Act.
Okay, thank you, sir. So, for law students who are graduating now, so what do you suggest them? Like first they should specialize in the commercial laws so that they can work in the commercial courts, or first they should focus on mainly general civil laws and then come back and specialize this?
It is better that they go for civil law.
Okay.
There is no shortcut to commercial court. Okay. Commercial court is also a civil law. It is only exclusive commercial disputes which come to commercial courts. So therefore, there is no separate law for commercial court that way. It is a civil procedure which has to be the one which is the foundation for all the laws, civil laws. So therefore, I would say Youngsters, they should concentrate more on practicing on the civil side, and particularly in the areas like where we have these commercial courts, which could be probably the next generation nature of disputes which go to commercial courts. Because as I said somewhere, commercial court law is going to be the game changer, which is a short, effective and viable and best alternative in the existing system.
Okay, sir. Say for example, if you are hiring a young advocate or a lawyer today, so what are those certifications or the skills or the qualities should we as a law student must focus upon, so that we'll be court ready or courtroom ready to get into this?
There is nothing. Just get into a good office, an office where the senior is having good brief on variety of cases, variety of skills required. Come up the ladder. Take your own time. Don't be in a hurry to practice in the commercial court. There are other cases. Good civil cases are there. Partition disputes, money related matters, 138 proceedings, that is to say section 138 proceeding. All these are good practicing, good for practice. So keep all that in mind. Slowly improve your skills, learn the skills of practice. Slowly over the years, concentrate on commercial court. You first love the subject, then it loves you. That's how you can take it. Take it stage by stage. There is no hurry. There is no need to be in such a big hurry.
Okay, sir. So, do young lawyers or fresh law graduates have a future in ADR?
Definitely. I think I can definitely say the future of India is dependent on ADR.
Okay.
ADR, in particular, mediation. So arbitration, mediation, these are the future of Indian litigation system. People can't be always restricted to conventional court practice. These are the new areas, new mechanisms which are overriding and taking a lot of importance in the Indian scenario. So coming to it, in one word answer, ADR is the key, and ADR is the future of India. And I think the youngsters should be focused more on these new schemes, new mechanisms, and focus and try to see that they become good ADR practicing advocates.
Give me some examples of nature of disputes which is covered under the Commercial Courts Act.
Okay, good. So please note, commercial court is also a civil court, but for commercial disputes. In other words, disputes as defined under section 2(1)(c) of the commercial courts are the disputes which are coming under that act, which are coming under that scheme. Other than that, rest of it will go back to or continue in the court, civil court itself. So there are many cases which can come under that. Section 2(1)(c) specifies 21 varieties of disputes which can come to commercial court. I can just give an example. Matter relating to trade, commerce, if it is of if it is emerging out of an immovable property. It could be bank related disputes, partnership disputes between the partners pertaining to hire purchase agreement, copyright, that is to say IPR disputes. So there are 21 such disputes which could come under that. These are to be now onwards, that is to say with effect from 23/10/2015 onwards, that is when the new act came in, Commercial Courts Act came, have to be resolved only by the commercial court of the jurisdiction. Another important aspect is the specified value, namely the subject matter of the dispute. So the subject matter of the dispute is to be more than 3 lakhs. If the matter which is in the court is less than 3 lakhs, it is not though it is a commercial dispute, it is not coming to the commercial court because it is a civil dispute which has to continue in the civil court. In other words, it's a commercial dispute but not above the specified value. If it is above 3 lakhs, then it is a commercial dispute and coming under the Commercial Courts Act. So 2 criteria have to be remembered. Section 2(1)(c), namely the nature of disputes and the specified value. So anything above 3 lakhs coming under 2(1)(c) is a commercial dispute.
Okay, sir. So what would be the advantages of commercial disputes which are resolved in the pre-institution mediation itself?
I would say the advantages are many. First, the objective of the act is ease of doing business.
Okay.
The parliamentarians probably thought it that the consumer, or namely, sorry, not consumer, the commercial disputant, who may be a manufacturer, distributor, trader, banker, etc., they should not be unnecessarily wasting their time in the courts, waiting in the courts for their case to be taken up. They should be doing their business. They should be productively involved in their business. So once they are able to devote more time to their own business or less time in the court, that is ease of doing business. So keeping that in mind, the first option is to go for mediation. That is a pre-institution mediation. If the matter is resolved in the mediation in the first instant itself, definitely they get to gain the entire time of going to the court later, trying to file a case, complete the trial procedure, wait in the court for years, because that would be over in the pre-institution and they would have taken a result, a win-win result in the trial, a win-win result in the mediation itself.
Yes.
So they save that litigation on one hand, they save that time, energy, and they also save the animosity. Please note, in a dispute, what suffers is also the disputing, what suffers is also the property or the subject matter of the dispute. The relationship is also strained between the two parties. Whereas in mediation, where they participate, the mediation, which is before a neutral third party, provides for a platform where they let out their feelings, uneasiness, and they become close to each other. They see the commercial interest between themselves, and naturally, the commercial interest overweighs against all other factors. Therefore, in the interest of the commerce or interest of their own business, they try to find a solution in mediation. So if you have asked a question whether commercial court mediation is helpful, certainly it has been helpful. I would go one step and say, if 10 disputes are referred to mediation, which is compulsory, even if 5 of them settle, that means to say there are 5 parties going happy home without their being, going to knock the doors of the court. For the institution, namely the courts, that 5 cases also will reduce this time, and that time is saved for litigating, using the time for a better purpose in a court. So court also, avoids this influx of cases by reducing the number of cases coming to the court. So it is good for the customer, namely the consumer or the commercial stakeholder. It is good for the system. It is good for the judiciary also.
Yes. So, sir, when the case is referred to pre-institution mediation, and if it fails to resolve the case, so is there any chance that it can be again referred to the mediation?
Certainly. It's a good question. Firstly, please note, mediation never fails.
Okay.
The attempt to mediate may be failing. Mediation is always a very safe one. Maybe the parties or the mediator have not been able to find a solution. That's all, to get the solution to the parties. If the parties or the mediation is not successful in that context, the litigation has to be filed. They have to file a case to the court. It will be before a commercial court. Once the parties are in the court, please note, they have all the facilities of a section 89 CPC, where they can further refer the matter once again to mediation or to any one of the other mechanisms, namely arbitration, conciliation, lok adalat, anything. So it doesn't mean that once a mediation has failed, it fails forever. It has failed that time, that's all. Maybe once the litigation has started and parties are before the court where they put across their pleadings, maybe it is well suited for a settlement in mediation or any other appropriate dispute resolution mechanism. So please note, what applies before going to the court is section 12A of the Commercial Courts Act, that is to say for mediation. What applies after filing of the case is section 89 CPC for the parties, under which the options are many more. As I said, all the options of the ADR is also available to the commercial disputant. New mechanisms and focus and try to see that they become good ADR practicing advocates.
Okay. Thank you, sir, for your honest advice. It definitely helped us to understand the difference between the classroom and the real life courtroom experience. And for lawyers, remember that knowing business is as important as knowing law. We'll be leaving all the description box. Please check it out. Thank you for joining us today.